So the first part of this video is going to be about this incredible allegations coming out of the trustee against Girardi Keese with loans. And I'm going to share you something I found, which I'm dying to get your feedback on. And then the second part of this video, which will be about halfway through, we're going to talk about Erika Jayne Girardi and what happened with her win, and from both her perspective and Ronald Richards' perspective and his client's perspective. So you could sort of understand what that win meant. How does it all play out? Okay, so enjoy. So we are going to discuss Erika Jayne Girardi legal update because I see a lot of people now getting confused as there's been so many different results that are in different life cycles. And people aren't sure if they're dead or alive or if it means good things or bad things for both the people that lost their money to Tom Girardi's scam, and also Erika Jayne Girardi's continued, constant evaluation of whether or not she knew or didn't know and was there wrongdoing, etc. So I thought I would do this video to help out and do some of the legal highlights and let you guys know what's kind of going on as a cliff note. Now, before we get started, I had found something a long time ago, back when Jay Edelson had first filed his lawsuit. I noticed that there was a company that Erika Jayne Girardi was a director on, and it seems to have sort of been lost in all the noise, and I want to post it here. That document, that's from the Secretary of State of Nevada. And, very strange to have a loan company, right, in Nevada that Erika Jayne Girardi is the director of, and so is David Lira. The website was pretty weird, too. Anyway, I guess what I wanted to call out even weirder was look at the formation date. I thought that was very strange that he started a loan finance company back then, because you have to remember that they reported when this story first broke that Tom Girardi had started doing sketchy things with his clients' money as early as almost 20 years ago. And so if you look at that date being 2021 or even 2020 towards the end, right? Because I think that's when the story broke, when Jay Edelson filed his complaint in Illinois. That would be right around 1999. So I was like, geez, could this have been sort of some of that thinking? I don't know. Anyway, feel free to comment below what you think this is. It's still a mystery. No one's really figured out why this company exists. Yeah. So what happened was Jay Edelson had listed this company on his original Illinois case. And I looked it up, and there was Erika Jayne as a director of it. And I thought to myself, why would Erika Jayne be on a loan company that Girardi was Tom Girardi's company? And why would David Lira be on a loan company? That didn't make a lot of sense to me, as their primary business is lawyers, and Erika Jayne doesn't seem to have anything to do with loans. And I did go to the website, which since has been taken down, and it was really odd loans. It was loans for property, loans for equipment, and you could also just request general loans. It was so strange. So they actually had a place where you could submit a form if you needed a loan, and they would help facilitate this loan. Anyway, to me, I was like, loans can be pretty sketchy business. There are ways for people to hide relationships sometimes, maybe, protect assets that they want to make sure there's extra layers of protection. They sit on a balance sheet like an asset, even though they're a debt. So it's really wild stuff. So I thought it was really interesting that they had a division or a company that did loan facilitation. So anywho, I looked a little further into this and I didn't get any traction. Not the first time my research has ended in a hole with nothing. But then I noticed that recently the trustee had called out that she believes that there has been legal funding fraud, essentially. that Girardi Keese had taken part in. And how they did that was there was a company, I'll show you the legal document in a minute, and that company had a big law firm go out of business that they had lent money to. And that law firm had tons of cases. So what they did was they took all of those legal cases away from the law firm that went bankrupt, the legal funder that this company defaulted, and handed them off to Tom Girardi and Girardi Keese. And once they handed it off to Girardi Keese, they basically said, well, now we would like a commission for bringing you these law cases that we inherited from this law firm that didn't pay back their loan. And so we basically got these as like a creditor. So I guess Tom Girardi then paid them a commission on all these legal cases, but they also funded all these legal cases. And they had seemingly very unusual loan conditions because Tom Girardi on many occasions didn't pay on time the loan payments that were due, didn't follow the rules that they allegedly agreed, and seemed, at least to the trustee after doing an investigation, to function almost like a partner of Tom Girardi's or an associate in a sense. Not really like a third-party legal funder at arm's length. Now, the trustee goes into great detail as to examples of this. Now, to make this case easier to understand, I'm going to tell it like a fairy tale because that's so much more fun even for me. And then I'm going to read you some boring shit for about 3 minutes. And then we're going to move on to Erika. Okay, so hang in there. Once upon a time in a place of Beverly Hills, there were two legal funders. One was called California Attorney Lending 2, or Cal 2, and the other was called Counsel Financial Services, LLC, or CFS. And this fairy tale is about their bullshit relationship with Tom Girardi, which was presented one way, but actually might allegedly be another. So who are these friends in this story? Weitz Luxembourg, the law firm, Thomas Girardi and Girardi Keese. And CFS, Counsel Financial Services, LLC, a Delaware company. They've been friends since 2005. They were such good friends that they actually gave each other cases and took 50% commission off those cases on what they would make if they won. In 2011, Girardi Keese got a line of credit of $5 million from Cal 2, one of the defendants in this case. And that deal made everybody very, very, very happy. Cal 2 had some news that happened. Massey Vitito, a big law firm with thousands of cases, went bankrupt, and Cal 2 was the biggest funder for this law firm. And so they got all of these cases that were unfinished as part of the deal, right? They got their cases back and they had to give it to someone. So guess who they decided to give it to? Because they had this amazing 50% commission referral program basis with Tom Girardi Keese. Guess. I bet you can. Yes, you're right. Tom Girardi at Girardi Keese gets all these cases. Yes. This commission deal was so sweet that, would you believe, Tom Girardi never paid $1 of the $5 million line of credit that he used in his legal cases towards expenses that they had given the funding for. And in fact, he took 2 more loans out, and the total amount was $8 million that Tom Girardi and Girardi Keese owed this lender. But for some reason, they just didn't care. They didn't care if he even paid the loan back. That's odd. What's really strange is Tom missed the loan payments, didn't adhere to their loan documentation as far as the loan was concerned, and didn't pay any interest payments. Not a typical loan, I'd say. So one of the owners of Cal 2, this legal funder, was really worried because Tom Girardi, I guess, had to come clean and say, listen, I haven't paid any of my legal funders, and they're now wanting to come after assets. And, you know, you and I have kind of a sweet deal going, allegedly. And so guess what? The owner of Cal2, or one of the shareholders, decided to negotiate deals with all the other legal funders on behalf of Tom Girardi. That's kind of a weird relationship, don't you think? And would you believe that Cal2 was so generous that when they went in and negotiated with the legal funders that were threatening to sue Tom Girardi and Girardi Keese, they offered money to settle those loans before their own, even though they were prioritized higher than those legal funders in getting paid back on legal cases that won. Which is a very strange commercial logic for a legal funder to take, unless there's a personal relationship there or something that they're trying to protect. Or they've made a shit ton of money and they don't really feel the priority need to collect. They just want to keep the sweet deal continuing, right? They don't want anything to jeopardize the future of the sweet deal they have. So they're like, forget our loan. Who cares? We've already made our money and then some, which might be questionable ethically. Let's just say that. Don't just take my word for it. The trustee is informed and believes, and based thereon alleges, that the CFS defendants, the lenders I discussed with you, Cal2, are implied in fact partners of Girardi Keese, or alternatively that the CFS defendants are insiders of Girardi Keese, and that the CFS defendants' claims should be recharacterized as equity. Assuming arguendo, the CFS defendants' claim is not recharacterized as equity, the trustee asserts the claims should be equitably subordinated to the claims of Girardi Keese general unsecured creditors, including Girardi Keese former clients. In addition, the trustees assert that the CFS defendants' referral fee sharing agreement violated rules of professional conduct, Rule 2-200, now Rule 5.4, and Rule 1-320, and hence are null and void as against public policy. Based thereon, the CFS defendant should be ordered to disgorge all money received from Girardi Keese based upon the illegal and unenforceable fee-sharing agreements. This is the best part. The trustee also is alleging claims against the CFS defendants, the Cal2 people, for conversion in failing and refusing to return to the trustee the $1,772,500 they obtained directly from Boeing in the Lion Air case, based upon a fee-sharing arrangement with Girardi Keese, notwithstanding that at the time of the payment, Girardi Keese had improperly paid itself in full. Thus, the payment should not have been made, and the CFS defendants have no legal claim to that money. The CFS defendants have refused to turn over the $1,772,500, notwithstanding the CFS defendants' knowledge that they are not entitled to keep the money, and that keeping the money constitutes a crime under California law. The trustee also presents additional claims against the CFS defendants for aiding and abetting Thomas in his looting of Girardi Keese IOLTA accounts for the 7 years prior to the bankruptcy in an amount in excess of $23 million. The trustee is informed and believes, and based thereon alleges, that for years, the CFS defendants had actual knowledge of Girardi Keese and Thomas's failure to pay Girardi Keese clients, the settlement proceeds they were entitled to receive, and 2, Girardi Keese and Thomas' failure to pay co-counsel or referral fees, notwithstanding that Girardi Keese received the contingency fee from specific representation. Yet despite the actual knowledge, CFS continued to support Girardi Keese business operations, knowing that they were doing business with a firm and an individual who was not to be trusted, and who regularly failed to pay Girardi Keese's obligations to its clients in breach of Thomas's fiduciary obligations to do so. The trustee is also alleging claims for fraudulent conveyance, both actual and... So then she puts something very helpful in a footnote. She says that litigation funders that provide loans to people like, Tom Girardi and Girardi Keese, they usually do it to cover costs and expenses incurred in complex contingency cases, right? So that they have the money to fight the case. It is an unregulated industry. There's not a lot of regulation around it. And the financing is expensive, with large fees and annual interest rates typically starting at 18%. Default interest rates can range between 24 to 30% or more. So what she's saying in this footnote is that there is no damn way that if Cal 2 wasn't a secret partner of Tom Girardi's, they wouldn't have collected on these outrageous terms that they could have if Tom defaulted on his payments, which he did. That leads us into two possible motives, if this is true. One, they made so much money on the referral fees that they weren't supposed to take, but did take on giving Tom Girardi cases, that they didn't care about the loan. Or two, it was never really a separate company. It was a company that was somehow like a shareholder in Girardi Keese, but on paper, it looked like a third-party loan company. And there was some sort of integrated relationship between Cal 2 and Girardi Keese. That, at least, is what's being alleged by the trustee, is the only possible commercial logic for the relationship to have gone down in the way that it did. Now, what does the trustee hope to accomplish with this complaint? One, she doesn't want to have to pay this loan company back their debt from Girardi Keese because A, their agreement, in her opinion, was illegal, and B, she sees them as a secret partner or, a partner in action, let's say. The other thing she hopes to accomplish is to claw back money that they took from Girardi Keese, including the money specifically taken from the plain victims, families, and get that back from this company in a court order so that she can then pay it out to the correct people. Now, I plan on dropping a video tomorrow to take you through all the things that the Judge Trisha Bigelow, got from Tom Girardi, which, after she heard the LA Times was doing an article, promptly returned to the trustee to make sure that there was no question of, the fact that she wanted to undo anything that might look inappropriate. So I'm going to do a video about that tomorrow because this one would be too long otherwise. Now let's get into Erika Jayne Girardi's case that she seemingly won. Okay, so there was a lawsuit, one of many lawsuits against Erika Jayne Girardi for $5 million. And they were alleging that Erika Jayne Girardi knew that the money that they didn't receive, these lawyers that were supposed to get this $5 million, they alleged that Erika Jayne Girardi knew that that money belonged to them and still allowed Tom Girardi to spend it on their lavish lifestyle, which is a very high threshold for them to prove. Okay. So Ronald Richards was involved in this case, as he has been in many of the cases against Girardi Keese and Erika Girardi. And that's mainly because he knows the case so well. So a lot of people go to him because he knows the ins and outs of a lot of different perspectives of it. And so he can come, I guess, at it from a bunch of different positions. But anyway, in this particular case, what Ronald really feels is that there's no way in hell that Erika Jayne Girardi should be able to say that she did not know where the $25 million given to her company, which she's the sole owner of, came from. Because in his mind, it's a lot of money, okay? $25 million. And it didn't go to her personally as a wife. It went to her as a businesswoman and her company with nobody else in it. You are responsible for knowing where money comes from when it goes into a company. This is why there's money laundering rules, right? Or you could just be like, oh, like, I've got this friend and he just gave me 100 million and, it has an ethical obligation or maybe even a fiduciary obligation to say to her husband, that's a lot of dough. Where's it coming from? So I know that it's good in me accepting it through my corporation, not just I'm a dumb broad. Don't worry about it. Shove it in there. What do I care? Pass the diamonds. Okay. And so that's really his fundamental, like where he's coming from. And then, you add to that like the 12 million in American Express payments, which I'm not sure if that was in addition to the 25 million or inclusive in it. But it's just like at a certain point, you do have an obligation at that level of money to know where it's coming from, even if you're married, if it goes into a company that you are the director and shareholder of. Otherwise, people could commit fraud that way all the time. Ronald is suggesting that what's being argued is what constitutes actual knowledge. And he's saying you cannot willfully have a blind eye towards something and that be okay, an excuse. Just like, by the way, supposedly in our criminal law system, you can't say, well, I didn't know that was a law and use that as a defense in breaking that law. Tough shit. You better know the law. It's basically the government's attitude. So Ronald's kind of saying the same thing here. He's going, it's not okay to just say, well, I didn't know he was stealing hundreds of millions of dollars. Although I was married to him for 20 years and I sat as a director on some of his companies and I received a shit ton of money from him and other things. It should be inferred that you knew where the money was coming from because that is the appropriate behavior. So this is where it's a gray line. But can you imagine if you went around and said, I put $10 million in my bank account because I found bags of cash in my house. And they're like, but your husband's a drug dealer. You didn't know those cashes were coming from the drugs. You're like, oh no, I just saw the bags of cash lying around the house. And I thought, I shouldn't have them there. I walked them over and I put them in the bank. I didn't know that they were from drugs dealing. I mean, I just assumed cash around the house, cash around the house. I'm just a wife. I mean, I barely bank. It's the first time I went to the bank to put that 10 million in cash in there. So on Erika Jayne Girardi's side, because we got to do everybody's side, she's celebrating because there was no real concrete evidence, no matter what they put forth, that really showed that she was corrupt or that she intentionally knew that the money was bad and that she, aiding and abetting almost gives this feeling of like you actively helped someone do something wrong. And what she's saying is there's been no evidence that I actively helped him do anything wrong or that I, hid something intentionally, concealment. These are things that, I think, they would have tried to put forth and it didn't fly. So she's going, look, you got a big mountain to climb now. And if this precedent from this case is any indicator, I'm going to do all right. I'm probably going to not have any ramifications from any of the lawsuits that say that I aid and abetted Tom or was a front man to the scan or enabled him or whatever. Those are going to fail, which means I'm not going to have any liability and it's all good. It's all good. Now, Ronald's like, oh, hell no. Before you walk away, lady, just remember, I'm going to appeal and I'm going to try attacking from a different angle this time. And, and there's still a long way to go and a ginormous jury trial coming, which you are going to be implicated in. in some way or another, good or bad. So you're not done this rodeo yet. And Erika's like, bring it. And Ronald's like, I'm coming. And that's it. And I'm going to end the video there.